in today's session, what we will do is we will try and understand a little bit a background of the extant data protection laws in India first. And while learning about those laws, or while learning how to draft a privacy policy, we will also get familiarized with the entire legalities, or the law backing that requirement of having a privacy policy in place. So without any further delay, let's start the session. So one thing I'd like to ask you guys is, tell me, what is your understanding when a person comes to you that please draft a privacy policy for me? What do you think? What should be your first to do's? Okay, let me tell you simply what people generally end up doing. First, we'll talk about the blunders only. So whenever someone says that make me compliant with data protection laws, what happens is, generally there's a practice. What people do is they pick up the privacy policy, or pick up a standard draft of a privacy policy, copy paste whatever they understand should be best going into it, without understanding the organization or the polity, or how the organization is taking in sensitive or any other information from its users. And they just plain simplicity start drafting the privacy policy, update it as per the law, and give it to the organization to be put up on the website. Now, first and foremost, what a person has to understand while drafting a privacy policy is, it is not about just promising n number of things in your privacy policy. It's a backward approach. First, you have to create a process that how the data will be protected in the organization, and only then you should start drafting the privacy policy. Because privacy policy is like a promise that, okay, I am taking your data, I have done followed these, I have complied with these laws, and this is my policy. So your policy should be your end product after you have completed the entire process of data protection, or complied with all the laws that require you to do a number of things under the with the data which you have collected. And that should be a privacy policy. What people end up doing is they draft the privacy policy first, and then they realize none of the processes are in place. So I hope you guys are getting me that it is not a forward approach, it's a backward approach. You do the work first, then put it in the privacy policy. Simple. First thing first, why do we need a privacy policy? What are the laws that require you to have a privacy policy? Well, to begin with, the basic data protection laws in India, that is section 43A, and the sensitive personal data information rules, are the two key laws which require you to have a privacy policy. These are uh, the the main laws in India that deal with data protection. There are others, obviously, sectoral norms and sub legislations, such as RBI has its own, or IRDAI has its own data protection regulations. But when it comes to only pure simplicity data protection, these are the two main laws that come into the picture. Section 43A, which says that if any body corporate, keep in mind, doesn't apply to a person, it applies to only body corporate, which includes every kinds of businesses, partnerships, and it's a wider definition when it comes to body corporate under ITI. And these body corporates, when they take in your information, they need to ensure that that particular data is properly secured. Otherwise, the in case a person faces any loss, then that particular body corporate will have to indemnify the body corporate, that is, make good the loss that the person has suffered. Therefore, and also keep in mind one thing, unlike any other penalty provision or a jail provision, this is also dangerous because the liability under section 43A is uncapped. That means that if a person has faced a loss of 2 crores or above, also doesn't matter, the body corporate will have to make good my loss in case they have not been able to take care of my data. That is section 43A. Rule 4 specifically stipulates that a body corporate which is collecting information, especially those .com companies which are collecting information, are will have to maintain a privacy policy, and it stipulates the basic contents that a privacy policy should have. Rule number three, the third law, which is very new and will also now require a privacy policy to be in place, especially for intermediaries, that is the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which is very recent and will as and also stipulates the requirement to have a privacy policy in place. So let's move on to the next one. What does the rule 3 of say, like rule 3 of the SPDI rules say, which requires you to have a privacy policy in place? Very simple, uh, clear and easily accessible statements of practices and policies. As I said, you need to have your practices and policies of data protection in place, and then those have to be stipulated in clearly accessible statements. That means, see, remember, when you're drafting such kind of documents, you're not drafting it for counterparty lawyers. You're drafting it for people who are laymen and who are just visiting your website. So if you put in a lot of legal mumbo jumbo, it will be very difficult for them to understand. They are not your end target. You cannot use words like inter alia, as herein above stated, something like that. Simple statements. I'll show you an example of a privacy policy that I had drafted. Um, so it should be very clearly and easily accessible statements. Statements of what? The practices and policies that the organization has already done. Second is the type of personal or sensitive personal data collected under Rule 3. Now, under the same data protection rules, SPDI Rules 2011, there's a list of items which we typically are categorized as sensitive personal data. It includes your biometric information, it includes your health data, your financial information. It's a laundry list of items, and it includes passwords. So this kind of information, whatever you're collecting, you have to put in the privacy policy. Third is the purpose of collection and usage of such information. Now, as people who generally do a copy paste job out of the entire privacy policy, they, irrespective of why the data is collected and what is the end use, they write the same thing. However, that should not be the approach and may backfire at a later stage, because see, there was a time when courts did not bother what was written in the privacy policy, but now days are changing and courts are actually picking up the privacy policy line by line and asking the particular body corporate that, tell me um, where in your privacy policy have you stated that this information will be shared outside India or say some other body corp. And that time the companies have nothing to say, because they have not put it in their privacy policy. They have not let the people know the end usage of the information that they have collected. And suddenly when they are pulled up, or a disconcerted customer just comes and says that, my data is being shared. A very good example is those the app that was used in Kerala for COVID tracking, and suddenly they had decided to share the information with some foreign company, and the court said that, tell me, have you stated that in your privacy policy? And if yes, then locate it for me. So these are the points that you should have in mind, that it is not a straight jacket fit all formula for drafting a privacy policy. It is not that you have a set format in draft it and just give it. Every organization will have different kinds of sensitive personal data information collected, different final end use of the data being collected, and the purpose or the way it is processing the data will be completely different. So all these things will have to be kept in mind. Anyways, we'll come to that later. Then is disclosure of information, very important. So under the SPDI rules, you can disclose information only on two scenarios. Firstly, when the disclosure has been consented to by the data provider. Very important. See, what you have to understand about the concept of consent is that consent can be given and taken away. So tomorrow, today I'm giving my consent to process my data in a particular manner. Tomorrow I may withdraw the consent. What is the other ground? The other ground is you are providing a service, or providing performing an agreement on behalf of the other person, and therefore you're required to disclose some information to third parties. Now that is the second criteria. And lastly, the reasonable security practices and procedure. Now, what does the SPDI rules say about reasonable security practices and procedures? Very simple. See, it says that depending on the type of data that you're using, okay, or the data you're collecting and processing, you will have to have your security practices and policies in place, which should not be lower than the standards of ISO ISEC 2001. Okay, this is the basic criteria. Now the problem with that no data protection legislation in anywhere in the world states a benchmark of having a security practice and procedure. It is only in India where we have such things in place. And it also states that any other industry practice which is sanctioned by the government can also be used as a reasonable security practices. I'll tell you, ISO ISEC is so simple that even a child's video game will have an ISO ISEC compliance. It's that simple to comply with. That is the minimum criteria of reasonable security practice in India. And if you have complied with that, it is as per the law under Rule 8, it is deemed that you have complied with the reasonable security practices and procedures. Now, as we all know that the sphere of data protection and data privacy is changing, and it is now no longer, and our present data protection laws, to be honest, is a bit rudimentary and can be done away with, but like there are multiple loopholes in that, and we are slowly venturing into a new regime of data protection. And as we all know it by the name of the Personal Data Protection Bill 2019. Now you see what I've been explaining from now for so long, that it's a backward approach, is now been embodied in the form of a legislation in the new bill. How? It's saying that you have to privacy by design. What it means that, see, that one size fit all approach will not work anymore, because an hospital taking in information will have a different design for privacy, and a .com which is selling clothes will have a different design for privacy. So what it is requiring the data fiduciaries or the persons who are taking in such information to do is to design a privacy policy as per the requirement of the organization, which is completely different from what we saw under the previous or the existing law. That is, it just says that you need to have XYZ things. It doesn't tell you to do or have a privacy by design and policy which will be made to order for your organization. So what does it say? The managerial and organizational business practices and technical system designed to anticipate, identify and avoid harm to the data principle. It just sets principles. It doesn't say do XYZ things. It says that, do whatever you want, but ensure that these obligations of yours are fulfilled. First is the data principles, data has to be protected. Second is the obligation of the data fiduciary has to be clearly highlighted. Then the technology, no matter what technology, see, like the existing bill, it says that have this ISO ISEC compliance and you'll be sorted. It doesn't say so. It says that it has to be in commercially accepted standards. Like, for example, you're dealing with in a financial sector, and your data protection compliance requirement may be of a very high standard, maybe the PCI DSS, the highest standard possible, or the most latest PCI DSS compliance requirement. And an ISO ISEC will not work there because it's too, what to say, it's too rudimentary to have a lenient privacy policy or a practice like that. So it says that technology should be according to your market standards. Next is the legitimate business interest is achieved. Now, whatever you want to do with your business, you do, but that should not compromise the privacy interests of another person or the person from whom you're taking the data. And the protection of privacy through processing from the point of collection So the entire life cycle has to be stipulated now under the new data protection bills privacy policy. And the interest of the data principle is accounted for at every stage. Now, from data in an organization has a life cycle. It goes in around from collection to processing to retention and then deletion. So you have to ensure that every stage, the data principles, personal data rights, the rights of the data principles or the interest of the data principle is accounted for. So see, it's a shift from doing requirement to you of for you to do two, three things for and mentioning it in the privacy policy to having a requirement of principles. It doesn't state tell you the know-how or the exact to-dos. It says that get this done. How you get it done is completely different. Is your prerogative, but ensure that these are complied with. It's more of a moral obligation or obligation at a principle level rather than at a compliance only perspective. So that's a shift that we're looking forward to. Anyways, these are yet to come, and when we will draft privacy policies under the PDP bill, we will have to ensure that these are complied with, and hopefully it will be a better scenario than what we see nowadays in the form of privacy policy. Okay, so even now when we draft privacy policy, uh, we'll have to take care of a few things. For example, first and foremost is consent. See, consent is very important, and the concept of consent has changed over a period of time. Even though the law or the statute does not expressly say so, but the courts are expecting that the consent is taken in an informed manner, and people with and it is brought to the knowledge of the relevant person before the consent is given by that person, that what he is consenting to. Unfortunately, even now we have lot of websites where privacy policy lies around in a corner with very small letters, pages after pages, without people being unable to understand what they are consenting to and what is that I agree that they're clicking on. On top of that, it also states that the consent has to be with a can be taken in an electronic manner. So most companies, what they do is they do a click wrap contract, or which is mostly a contract of adhesion, which means that you take it or leave it. Like, you want to download WhatsApp, agree to our terms and conditions. If you don't agree to a condition, you don't consent to it, then I'm sorry, you cannot use it. And mostly it is like that. And like any other person in this country, or we generally click on I agree and move ahead with it, because who has the time and the patience to go through the privacy policy and see if there are data leakages to Afghanistan. Anyways, so second thing is notice. Notice is very important because now, although in the present law, the requirement of notice is very simply put, that the person has to have knowledge and all. It doesn't talk about a clear formal notice to be given about what information is being collected. But if we see the new data protection bill that has come into the place, we will have a law some date where a clear notice in multiple language will have to be given to the person before uh, before collecting any information. Second, sorry, the third thing is choice. Now, this is the most ignored part of the privacy policy. And actually, even under the present law, there are multiple places which requires the companies or the body corporates to give the users a choice whether they want to go ahead with it or not. And yet, again and again, we see instances where the element of choice is missing. They don't really give you a choice whether you want to go ahead with this or not. A very good example we'll be dealing with is the Karmanya Singh case, which is in 2016, not the 2021 color, the previous to Karmanya Singh case. And we will realize that how element of choice is taken away from our lives on a daily basis, as if it is as if it is the right of the body corporates to do so, whilst it is not, because it requires you to not only have choices, but in fact, even in case of informations that you have already provided, you have the right to go and correct it under the extant law itself, under the existing law itself. Now, these elements of choice are clearly avoided in a privacy policy. We'll realize, we'll see how that backfires in certain cases. Next is purpose for which the information is collected. Now, people tend to write a laundry list of items, irrespective of why the information is being collected, or in fact, most of the time, the lawyers don't even know why the information is being collected. What is the end use of the information being collected? And they just write just for being on the safer side. Let me write a blanket statement, someday it will come to our use. That shouldn't be the approach. Next is the disclosure of information. As I said, the disclosure can be under consent, or if you're performing an obligation under a contract, only then you can disclose the information that you have collected. And lastly, the security practices, which we dealt in detail, that ISO ISEC requirements, which says that if you have complied with these, then you are um, through with having a proper security practice in place. However, you'll also have to mention it in the privacy policy, that what is the standard of data protection that you have, or security practices that you have followed. So let me draw your attention to this line, which a brilliant word said by Chief Justice Bobde, which says that you may be $1 trillion company, but people value their privacy. So this is in context of the WhatsApp case. Let me start with the 2016 scenario, where WhatsApp was acquired in 2014 by Facebook, and in 2016 WhatsApp had unilaterally decided to share your certain information from the chat records, um, or your metadata with Facebook to improve the service over Facebook. And so two students in Delhi High Court filed, one is Karmana Singh and then is Shreya Sethi. These two people had a problem with that how can a company just take my data and just decide to do whatever it feels like by giving it to another entity without a proper consent requirement. So they went to Delhi High Court. Delhi High Court, obviously, because of the lack or the dearth of legislation, they just said that they rejected the petition. But what they said is that only those people who have consented to the privacy policy, you can share their data. Any previous data users who have not consented to it, you cannot take their data and give it to another person just because they have not consented to it now, because you're asking them to consent for something which they have previously given. And if they have not given, you anyways giving it to Facebook, that will not work. So you have to delete their data, whoever has not consented to it. Whoever has consented, you can share the data, obviously, and they can continue using WhatsApp. So this bifurcation was created by Delhi High Court. Then this case moved, the petitioners only moved to Supreme Court, and it is still going on. In the meanwhile, what happened is the new WhatsApp privacy policy fiasco that you just heard, and there was so much of ruckus during the pandemic about, came into the picture, where WhatsApp had categorically mentioned that, the kind of data that can be given out, that will be given out to Facebook and all that. And if you see, very slyly it had mentioned that this will not be applicable to European Union, because they have already faced a backlash from the European Union data protection authorities. So your only crime in this case is that we do not have a proper data protection legislation in place. And this is the reason not only just entities like WhatsApp or Facebook, but many .com entities on a daily basis are exploiting our data, our data on a daily basis. And it is in this context when Justice Bobde clearly said that, you can't do all this nonsense in European Union because they have a proper law in place. And now you're doing all this in India just because we don't have a proper law. Where is the parity? Where is the equity in this case? There was a definite dearth of equity. So this case is still going on. Another example of a bad drafting of a privacy policy is, I can't name the company, but most of you will be able to guess it. That it's a famous telecom company, and apparently it provides only network services, but it collects information like your sexual orientation, your genetic information, and your political opinion. Now you see how this is a solid example of a bad drafting of a privacy policy, because A telecom company has zero users for such kind of data, but they have just decided to keep it, and for the sake of the lawyers have drafted, or their lawyers have drafted it just for the heck of it, understanding that, let it be there. What's the harm? What happened is a backlash from the users saying that why are you collecting these information, and they had to come out and publicly apologize, saying that this was a drafting mistake, and we don't really collect all these information, and we will be careful, and they had to amend the privacy policy. So these are the things or the background that you need to be careful about while drafting a privacy policy. I'll show you a small example of a privacy policy that I had drafted. Yeah. So see how it is to be written. For example, the best way I find is to make it more conducive for a user to read. Like, for example, make it simple sentences. For the way I have written it here is, what personal information do we collect? Okay, so we say that when you're browsing, uh, just visiting, we are collecting a limited number of information. But when you register, we also collect XYZ information. Then I have stipulated the exact personal information that is being collected. What I have done is, in this process, I've safeguarded my client already for a future backlash. Like, people cannot say, oh, when did you tell me that you're collecting all this information? So what I did, I asked him that just carefully go through your process and see what information are you collecting when a person is registering on your website. And okay, obviously there are terms and conditions also under which people will give more details, and that is captured somewhere else. But um, this is briefly when a person is visiting, and your privacy policy should state that what information is it collecting. Acha. And also I have stated that other non-personal information, for example, cookies. Most of the time, what when we visit a website, what happens is the website also tracks some of our activity. These are typically called cookies, and so it is good to have mentioned, although it doesn't have a privacy impact per se, mostly metadata, but it's good to have it in place, a proper cookie policy, and put, at least place a link of that in your privacy policy. So here I have briefly explained to an audience now, or the person who's visiting my website, see, these are cookies. This is what it means by having a cookie on your device, and this is how we are collecting it. For a more detail, please look into my cookie policy. Second, I have stipulated it and clearly laid down the n number of criterias or the end users of those information that I have collected. So you see, we collect information for legitimate business interest. Obviously, like, you can't run a website and not expect to automatically collect some information, or someone registering it and asking you, and you need the information of that particular person, information of that person, to process or respond to that particular person, or provide him with offers. So next thing what I have stipulated is the information that why we need it, what we will do with your information, and lastly, whom will we share it with. Very important. Now, what we generally see is dark patterns, which is uh, you people click on I agree, thinking they're agreeing to something, but what these technological .com companies end up doing is they give that particular information, or take that particular information saying that we'll do XYZ things, and end up doing ABC things which this person didn't even agree to. And these are called dark patterns. Even sophisticated jurisdictions like the European Union is struggling with cases of dark patterns, where coms are continuously taking people's information saying that they will do ABC, and they're doing end up doing XYZ. Next, you see how user friendly language can be used. So I have clearly said how safe is your personal information with us. So then we have said that we have put in appropriate technological measures as required by the law to ensure that there is there's no theft, unlawful processing, loss, destruction to your personal information. And lastly, I have stipulated what rights that the user has under the law. So again and again, I have tried to make it very interactive. For example, this stems from Rule 8 of the SPDI Rules, right to maintain an updated, accurate information. What many people don't know, even under the present legislation also, you have the right to update your information and make it more up to date. I have provided the users with the right and ask them to write to us in case they find their information is outdated. Right to access and be forgotten. This is something which we have given in addition, that you, if you want, we will delete all your data. Right to know about changes in the policy, and what is period, which is technically missing almost in every privacy policy. They just decide to change the privacy policy unilaterally and expect the people to know it. However, the correct approach is that you should have your you should notify that there has been a change in the privacy policy. And lastly, a breach notification and a right to opt out in case if you don't want, or if you don't want targeted advertisements, or you think it's a spam, don't want it, don't want to see it anymore. Right to opt out, no problem. And see, it's not about what I put in here is important, because I had to ensure that the basic compliance of GDPR is complied with. Basic. I'm not saying that you sitting in India can be a GDPR expert. It's near about impossible to do that. And what I'm saying that we had did a basic compliance of GDPR, and we had to draft the policy accordingly. But it's more about the language in which you have drafted. It has to be very, 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 or user oriented, or a layman, as if you're drafting or making the person who's a layman who doesn't know anything about law to understand that why his information is being taken, what is will be used for. and all this, although the law at this stage does not require it, but there are instances where although the law doesn't require it, and companies have gone and done it, and they have faced a huge backlash either in a public sphere, or they have faced a backlash in the courts of law, where the courts have had it with them when they were unable to produce proper privacy policy. Okay, so last is do's and don'ts. As I clearly said, understand the approach, understand the organization, and then draft. It is not a backward approach that you will draft the policy first and then complete all the process of data protection. No, whatever you want to do as a part of data protection, complete that, because a privacy policy is more like a promise. A privacy policy is more like a promise of what you have already done. If you don't complete those things and then draft a privacy policy, what will happen is that you're not only in breach of the law, but you will also be in breach of your own privacy policy, because you have promised an n number of things in your privacy policy which you have not done. And then a disgruntled user will come and say, look, you have not only breached the law, but you have also breached the privacy, your own privacy policy. Second thing, use clear, simple, and precise statement, as I just showed you. So make it more for a layman rather than a counterparty lawyer. Third, make best use of technology and hyperlink wherever possible. For example, as I showed you, I wanted to put a small um, description of a cookie policy, what are cookies, and we are collecting cookies, and then link it to the cookie policy separately. What I've asked the technician to do while drafting is that after I'm done drafting, I've asked him to just hyperlink the cookie policy word with the actual cookie policy. Third, talk to the technician who will be executing it. Now, as a lawyer, it is expected that as a technical lawyer, it's expected that you will know about what the technology is all about, what the basic terminologies of the technology. But it is not expected that you'll not know everything. For example, there are multiple kinds of cookies, okay? And you'll have to go and ask the technician to tell me what all cookies are you putting while developing the website. Just ask that person and then put it in the draft. Then that way it's easier. It's very similar to drafting a transaction document. You have to know what you're putting in. Get the term sheet from the technician. That Tell me what all information are you taking. Tell me what cookies are you putting on the website, and then draft it. Next is do not overstate promises and commitments. As I said, you say you promise the world, we have given you the best protection, PCI, DSS is blah blah XYZ and all that. But when you look back, the protections are non-existent. Then at that time, as I said, you'll be in breach of your own privacy policy. Do not write with the mindset just to be on the safer side. People write broad terms, you know, to be used in the manner as the company may deem it will not work. Simple. Do not write it with the mindset that just to be on the safer side, let me write it down. Someday kaam aa jayega. It will backfire. Just like it had backfired for the telecom company that I was giving an example about. That they had taken information like political opinions and sexual preferences. Lastly, remember the rights of the information providers. See, not if not today, someday there will be a scenario when it will backfire if you slyly put in all those dark patterns in your drafts, saying that we'll take your information and maybe using it for as it may deem fit, and you send the information and sell it to people in Afghanistan. Will not work. So these are the basic do's and don'ts of a privacy policy, and I hope I have been able to make you guys understand that how to go about it.
I just want to ask you, so our participants are either law students, lawyers, and even non-legal professionals. But
Hmm.
what are the duties of a lawyer? Like what are the duties of a lawyer in this?
See, as I had time and time again in the during the presentation also, I had said that as a lawyer, knowing all the technical terms is not possible. Knowing the organization entirely is not possible. Ask questions firstly before you draft a privacy policy. That um, understand that what they are collecting, why they are collecting, what is the end use. It will help you in drafting the privacy policy in a much lucid manner so that you yourself can also understand, and also the person who's reading it can also understand. See, it's a duty towards the society. Nowadays, there was a time when people did not think about privacy in India. But now people have started thinking, they are paying heed to it. If not a legal battle, you might have to fight a social battle if you do not things do right. If a lawyer does not do things rightly, just as it's told about the telecom company case, you know, they hadn't expected that after so many years, after doing business in India since like God knows how many years, and someone will pick up their privacy policy, and suddenly there'll be a social uprising saying that, why are you collecting all this information? So it
Yes.
was completely a fault on the part of the lawyer because he didn't, or that person did not ask the relevant question. That is very important, that you have to ask the relevant question. I think that is the foremost and the duty of the lawyer in a scenario like, could you please brush upon the electronic agreement? This is considering the consent through uh, electronic means makes the privacy policy binding on a data collector. So yeah, these are so immediately after 2011 regulations came out uh, on which requires you to have this privacy policy. IT, there was a lot of backlash from the IT companies, especially those BPOs, where they required that so many compliance, even under even the 2011 rules, they felt that the privacy laws are extensive. And so what our Ministry of Information Technology had to do is they came out with a press note saying that, okay, you can take consent, but consent can be taken electronically. What happens is, because of that, there was a press note circular immediately after that rules came out, and that's the reason why we nowadays, even those I agree tabs are blankly put and people click on it, and that becomes binding. So it is very much backed by law, which requires you to have a electronic I agree button. Can privacy policies provide for arbitration procedures for grievance of data subjects and data collector? Yeah, why not? Yes, it can, but generally, no one generally don't, because it's more of a mediation mechanism that people put. And you can reach out to us. It's directly, you don't just start putting the arbitration firstly, and secondly, see, um, if someone invokes arbitration proceedings, it may not be feasible for you because of the uh, mammoth amount of people visiting your website and trying willing to invoke an arbitration.
Yeah, I just want to ask that just now you mentioned that while drafting a privacy policy, a lawyer also need to take care of the rights of the users, right?
Hmm.
But the lawyer, what if a lawyer is strictly being told by the service provider that you have to draft a policy in such a way that it benefits us in a maximum way? So in that situation, how do you convince the service provider that no, I have to take care about the rights of the users
You
as well?
caveat it. Simple. You caveat it by saying that I am doing it, but I don't think this is going to go down well with you, or you recluse yourself from drafting such things.
Okay, okay. Thank you.
Non-disclosure clause. See, again, this is NDA is different from a privacy policy. Um, this is not what should be going inside a non-disclosure clause. Should not be going in privacy policy. You can uh, generally the concept or the crux can be put in like whom you're sharing your data with. That part you can put in that you will not be disclosing it with to anyone, but you do not have a strict non-disclosure or a NDA inside a privacy policy. Please summarize what is the status of the personal data privacy bill. Is there a possibility of becoming a law in the near future? God knows. Interesting question. Everyone has it in their mind, but no one knows when the data protection bill will come. Or please, can you summarize what points are required to be considered while drafting a privacy policy? Well, as I just said, I in my last list of do's and don'ts were actually a summary only of the entire privacy policy. What should be kept in mind?
Yes. Okay. So see, you are into drafting, and
Hmm.
we've seen in banking agreements also, okay, like the mutual funds and all. Uh, I like, many say that, on purpose they run into pages because they don't want people to read. So can there be a standard size for these privacy policy, or you feel that no, there are some organizations that need to have long privacy policies?
Firstly, I don't believe having a long draft for something which is read by a layman on a regular basis should be that long, because A, he's not a lawyer, B, he doesn't have the patience. It has to be, if you pick up the new bill, you see how a privacy policy should be or how our notice should be is clearly stipulated. It should be clear, concise, impart in particular knowledge about what is being done with what. So I completely concur with that concept or the principles of the new draft, which says that it has to be very, very simple, smart, precise, and to the point. Because as I said, we're not dealing with sophisticated lawyers on the other side. It's not a transaction document that well, there'll be people fighting legal battles. This is small people like people like you and me who value their privacy will
Yeah.
be reading it, right? So I will always favor a draft which is short, crisp. And you saw the draft that I put up on the screen, right? It was
Yeah.
question answers. Even
Yes.
you, when you read up a draft like that, you'll feel like reading it. Like, okay, just let me see what they're doing with my information. Let me see. It's so interactive. Make it more interactive. Don't make it look like an agreement. For that,
Yeah.
you have your terms and condition, which is like an agreement. I honestly do not concur with having long drafts, even with banks, because um, the previous organization that I worked in with, they always said that what can be said in 3 pages can also be said in 1 page or half a page. So stick to half a page, and that's the principle I live by even now.
I hope the clients also live by that principle.
If a client is asking you to draft pages after pages, then I think there's a disconnect whether he wants a, a legal document or he wants value addition.
I have a question. So
Yeah.
this might come out as a little controversial question because this is regarding the government of India. So now
Hmm.
recently, in around February 2021 only, Nitin Gadkari, he accepted that the government has owned say around 100 crores when sharing the data, private data such of certain companies with vehicles with private companies. It earned so the government of India earned 100 CR by sharing such data, some data of private vehicles with the companies. So my question is, can anybody sue the government of India? Or I mean, basically I'm asking is such data policy requirement also applicable to the government of India?
Fingers crossed, if the new bill comes in, then yeah, we can sue the government also.
Okay. Thank you, sir.
Thank you.